Salud. Good to see you. We're doing things a little bit differently today. As you can see, we're not in our office over at EDA Law in Redlands. We happen to be on the road getting ready for a high school reunion function. So in doing that, along with a few other things, we figured tonight let's talk about hearsay. Now, I know a lot of times people will say the phrase hearsay, but they don't really know what it means in a legal sense. So let's talk about what it means in a legal sense. Now, pardon me, we're going to have some lights issues here, as I haven't had to do this in a hotel room before, so it's our first time. Despite the fact that I represent people who do a lot of videos in hotel rooms, I don't have a lot of experience with those. So let's do this. First of all, what is hearsay? Hearsay is a statement that is an out-of-court statement that is offered for the truth of the matter asserted. Now, you might hear that and think, what the hell does that mean? And you're not the first one. As a matter of fact, that was one thing we said in law school a lot. But it works like this. In our system of jurisprudence, there's the belief that those things that are done under testimony, under the pains and penalties of perjury, not pains and penalties of felony, but pains and penalties of perjury, are much more serious and much more reliable statements than those that people make out of court. There's one reason why when you are told, for example, that or an incident happens and you give a report to a police officer, and later on you get a subpoena that tells you have to come testify. And people sometimes will say, well, why do I have to go? I already gave the information to the police officer. Well, it's because your statement was made out of court. It wasn't done under testimony. And dealing with the Crawford issue, there was no opportunity for the opposing side to cross-examine you. We'll address Crawford another day. That deals with the confrontation clause of the Constitution. It's an important and fun case. We'll talk about it later. But anyway, along with the hearsay, this includes documents. For example, the fact that you've written something. A lot of times people will say, well, why don't I just write it down and then you can present it to a jury? No, that's not how it works. That has to be sworn testimony. It has to be something that is also verified. For example, sometimes you can put in those documents that have been signed by have been recognized by a notary public because those are going to be authenticated. That doesn't mean that you won't need to come in and testify. You still will too. But it's one of those items that can be a self-authenticating document. There may still be questions regarding it. And I know all this sounds confusing, but this is important, ladies and gentlemen. It's one of the reasons why when something happens to you or when you're involved in something, it's crucial for you to go ahead and testify. Because just saying it happened is never going to be enough. Now, that doesn't matter whether it's been a robbery or whether it's been, for example, well, I have no problem telling you a slightly embarrassing story about stolen cars. For example, someone is caught with a car that doesn't belong to them. One might presume that they have stolen that car. Well, that's not a bad presumption. But for the law, the question is, well, how are we going to establish the car was stolen? You need the owner to be able to come in and testify that they did not give this individual permission to use their vehicle at all. And in many cases, the answer would be, I've never met this individual. There's no way I would give them permission to use it. So it's not just enough that the car is reported stolen. There has to be something more. We mention this, ladies and gentlemen, because these are not engraved invitations that you are getting to testify in court. These are court orders for you to come testify. And it's a necessary process of everything we deal with in our judicial system. At any level, that's going to happen. Now, there are also exceptions to the hearsay rule, and we'll talk about that another day. We do that because we don't want these videos to run longer than about 4 minutes, 5 minutes tops. We want to give you the chance to take them in the chunks. Now, you're also going to find that this time there is a poll with you. By all means, answer the poll. Take a look. It helps us determine what we're going to be doing next with you. As I said, later on we'll talk a little bit more about the hearsay rule and the right of confrontation. Now, we're mentioning these because these are not just restricted to criminal. This exists across the board. And so we're going to be dealing as well a little bit later on with some of the business law that many of you don't know. So don't be afraid to go ahead, send us an email or send a post or a message up on our Facebook page that goes ahead and lets us know what you want to know more about. In the meantime, again, te salud. We'll see you later.